Down in the shadows where the courthouse stands, a gavel cracks a fading hands. Judge Gould, they whisper with a crooked grin, played the game where justice don't win. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Prosecutor McLean with his papers tied wrote the tale that never saw light. Twisted words in a room of stone, left Rick Allen to stand alone. Who will answer? Who will pay? The sun don't rise on a judgment day. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Officer Holman, eyes like frost, drunk on power, the line got lost. Lock the doors, keep him inside, for justice limps where his footsteps stride.
Yo, folks, it is Friday, weekend, and of course, we are doing another reading of the Delphi Trial Transcript. We left off in the June hearing, which was, well, at that point in time, Rick's attorneys knew what Rick was subjected to. They knew about the supposed confessions. They knew about the Odinist theory, which the prosecution desperately tried to not. They desperately tried to not hand it over, but they found out. They found out anyway. So, in between that hearing and the one we are looking at today, the Franks motion that listed everything that the prosecution, the investigators failed with, surfaced. And all hell broke loose. That is when I got involved in this case because, well, Scandinavian and actual Viking, or a Viking descendant, is that the words? Well, whatever. Also, what's happened between then and June and October? Rick's attorneys, one of their former associates or something of the sort, broke in to the office and took photos of crime scene photos and then sent them to people. They are blaming the attorneys for being burglarized. Now, how do we know that is utter and complete bullshit? Because it's a criminal offense that they claimed against them, but they settled for disqualifying Mr. Rossi and Mr. Baldwin. So we are going to read from the record of in-camera proceedings held on October 19th, 2023. And I put a parental advisory on the thumbnail because this will get spicy. This will get spicy. Background a bit. This is the only time Judge Gull had cameras in the courtroom. More or less invites to every news organization on the planet, and then threatened Rick's attorneys with either fuck off or I'm going to place you in front of every camera and I'm going to admonish you for an hour straight. After we read the record of camera proceedings, we will watch the January 18th Indiana Supreme Court hearing regarding what Judge Gull did. Jennifer. Listening to yesterday's stream, but I have a question. Why and who decided to focus on Mr. Allen after years have passed? Why him? Because a volunteer of sorts, her name escapes me, but there's some interesting. She claims that she found a misplaced tip, Rick's misplaced phone in, and she claims it was he was improperly found to not have anything to do with this. Improperly. It's so much weird stuff going on with that woman. Oh yeah, that woman's daughter has on social media claims that she was honor bound to Ron Logan, one of the other suspects in this case. And then all of a sudden her mother finds Rick. Yeah, thank you. Kathy Shank. Kathy Shank. That's her name. Thank you, Low Light Recovery. And through that, Rick's 3 days later phoning in, meeting with an investigator, showed him his phone, and then was, yeah, fuck off. We are not interested. And then all of a sudden she finds that, and all of a sudden he's a person of interest 5 years later. There is literally zero things there besides him saying, yeah, I was there roughly between 12 and 1:30. I went out on the bridge, I looked at the fish, and then I fucked off home. And from that to this. From that to a firearms expert lying under oath about her results. Manufacturing evidence. The prosecution actively, in my opinion, those 70 days were never accidentally overwritten. They were destroyed. Because whatever was in those 70 days of interviews, in there you find the actual killers. But the actual killers, for some reason, had enough connections to make it go away. Out of fear, out of loyalty, I don't know. I don't care. So that is the short story of it all. But folks, be ready to be pissed off. Record of in-camera proceedings held on October 19th, 2023. Yeah, as Curfew says, it could have been any one of us. And this is why I nowadays say, when the cops say, we need tips from the public, please call in, even if you haven't seen anything, blah, 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 blah. Don't. If you're innocent, and you know you have nothing to do with a certain crime that is roughly where you have been, no, just don't, because you might end up like Rick Allen. All right, folks, can't postpone this any longer. Volume 3, page 5, appearances. Nick McClelland, James Luttrell, Carroll County prosecutor, and the Luttrell was deputy prosecutor. Brad Rossi, Andy Baldwin. Judge Gould, and court reporter Jody. Proceedings. This is in camera. This is in Judge Gould's chambers. So again, I can't trust that court reporter Jody actually, this is what actually happened. I think this is the cleaned up version, and it's still really, really bad. Attorney McClelland, Judge, I wanted to do some introductions. I finally got approval from our counsel to hire a paid attorney to help me, so the court, okay. McClelland, small town, local government. So this is Jim Luttrell. He's a retired prosecutor from Grant County. He decided or agreed to come on board. Special prosecutor. It's a small county, but McClelland has assistant district attorneys under him. He still hired another one. The court, okay, let's have a seat. McClelland, he signed the oath to my office. The court, okay. And all that, I'm going to handle a written appearance. Mr. Luttrell, nice to meet you, Judge. The court, nice to meet you, Jim. Mr. McClelland, next week. The court, okay. Or maybe tomorrow, Judge, if I get it done. The court, okay. But he will be entered in, and we are trying to get him up to speed. So this deputy prosecutor is still not actually on the case, but is still in this fucking hearing or meeting. Attorney Bradley Rossi. Well, I'm the one that kind of asked to huddle up. So if you want me to lead, or if you want me to say some things, I'm okay with whatever approach you want to take here. The court, go ahead. Mr. Rossi, well, I think the court, Jody's got a portable FTR going, so just that we've, Mr. Rossi, oh, okay, that's fine. The court got a record. Mr. Rossi, you know, obviously, I'm happy to hear that the court's going to make some decisions on the pending pleadings today. The court, oh, this is an ambush, folks. Judge Gould knows exactly what's going to happen. McClelland knows exactly what's going to happen. Brad Rossi and Mr. Brad, they are ambushed here, telling us that this was planned by McClelland and Judge Gould. Again, can you say ex parte? Mr. Rossi, I assume as Andy feels the same way, it's time to get some closure, if you will, with regard to those items so that we can move forward. It's probably obvious that the tension from our side is coming, from the words disqualification that were murmured in the phone conference that we had a couple of weeks ago. Where's the transcript of that phone conference? It's not in here. I'm assuming you understand how that kind of raises the intensity level of the circumstances. And I guess my if I have a concern today, is that, we're going to go out on the kind of in the public, so to speak, in the courtroom, on the record, and have a discussion about an ongoing investigation. And that's what I kind of gathered from the email. I think you invited Nick to talk about that if he wanted to. The court. Mr. Rossi. And it makes me a little uncomfortable because I don't know. First of all, there are no pleadings that are pending, whether they're motions to disqualify or contempt citations or whatever they might be, that really frame any of the issues. And I have no problem. I mean, I don't have any problem talking about this stuff privately on the record in an ex parte type confidential hearing. I just think it's difficult to expect that there will be any kind of structure to the idea, hey, there's an ongoing investigation and just tell us what's going on. And I don't know that it has any relevance to what we're really trying to accomplish today. And I also don't know why Nick would want to talk about an ongoing investigation in public, knowing that that in itself could be a little damaging to their circumstances. And so we're lawyers. We're used to having issues framed. We're used to having an opportunity to prepare. And I don't have anything to hide, and I know he doesn't have anything to hide. Who? Nick McClelland? Nick McClelland hides everything. Absolutely everything, if he can. You maybe gathered that we cooperated. We ran into the state police posts, our respective posts, if you will, and I had somebody advise me of my rights, and I waived those, and I gave a formal statement. He did the same. Okay. And I'm not sure that we're going to benefit or that this will be productive to just open floor this. And that's my biggest concern today. Judge Cole. Attorney Baldwin. I'm more of the due process side. I'm not really sure what will happen, but I just don't know. I don't know what's going to happen. And I would like the opportunity to know what's going to happen and prepare for their claiming or whatever before it happens. And I don't want to say ambushed, but it's hard to know for me what to do when I don't know what's happening. There's not a pleading we can respond to, things like that. So, you had indicated that, when Nick said, I don't know if he said the word disqualification, but the court, he did. Mr. Baldwin, was it that word? The court, Mr. Baldwin, okay. I didn't know if he just said it in a more generic way. The court, Mr. Baldwin. And your response was, I'm leaning in that direction or something along those lines. The court, Mr. Baldwin. And so that's, a cause of concern. I mean, we're still wanting to try this case in January. And I'm willing to, we had made changes at my office that will prevent this from ever happening again, Folks, when you are preparing for a case, you have your office, you have your room, you have whatever's, and you lay it out just to get an overview of this is the case, this is how it's going to happen. I'm going to see if I can find that thing. Hold on here. It is from the Karen Reed. When Janetti, I believe, had some of his. Damn it, where is it? Maybe I can find it here. Well, you might have seen it. It is him laying out the things he wanted to ask of was it well, one of the Alberts or whatever it was. Chris Albert, or Brian Albert, I don't care. And he showed the photo. This is how we're going to go through it, all laid out on the bench. The same in the Delphi case. They are having their war room, they are having the crime scene photos and the things, and they're going through it. They walk out, they do something, a former associate breaks in, takes photos of it. This is nothing unusual, but they are making it unusual. Let's continue. And we can take directives from the court. We can, we're locking down every single thing on Delphi. It's in a dedicated room. We put locks on our conference room or the war room where this guy my friend went in and did this without my knowledge. And no document, whether it's benign or something super, like a crime scene photo, is ever going to be left alone for a single solitary second ever again. So, I'm hoping that can be something that the court, can say, all right, that's fine, and then let's get on with the trial. But I'll shut up now. The court. Anything, Nick? Mr. McLeland. Judge, I guess my plan today was to give the court a summary of the investigation. They are so mad about the Franks motion. I am actually not putting it out of the realm of possibilities that somebody paid that friend to break in. I'm not putting it outside the realm of possibilities. Because we know Mr. McLeland, he doesn't care about justice. Everything in the Franks motion was something he tried to not hand over. Everything. And stuff are not handed over to this day. We know that. We found out after the trial that the white van that Brad Weber was driving, the timestamp is at least 15 minutes off from what the state claimed. At least. And that we weren't noticed about, we didn't find out until after the trial. Mr. McLeland, I got witnesses here and exhibits to present that go towards the investigation. I'm more than happy to hand those over to the defense. I know it may harm the investigation, but I think it would be important that the court hear these things. I guess the heart of it, inaudible. That is inaudible 17. Why I haven't changed anything in this. There, inaudible. So, Jesus Christ. StreamYard has reset my thing. Jesus Christ. Inaudible 17. Investigation. I think it's important. I think the importance of you hearing it is outweighed by that. And so I have those things. I'm concerned that the leak is not just a one-time leak. You yourself, Mr. McLeland, have leaked copious amounts of stuff. But this, yeah. The evidence that we have shows it's an ongoing leak. Liar. However, it's being done, and it's just, what's next? I have an issue. What's next? Well, you tell us, you fucktwat, because you are the one hindering any type of justice being done for Abby and Libby. You tell us, Mr. McLeland, you twat. I spent the past 17 days investigating this night and day when I should have been focused on preparing for trial. You mean focused on trying to plug in anything that remotely resembled something ethical of you? And when I say night and day, I mean phone calls at 2 a.m., 3:30 a.m., night and day. And so that's where I'm at, Judge. Again, I'm an officer of the court. I'm reporting to the court what I know, and that's kind of where I see my role. This Mr. McLeland is a bad prison snitch. He's the type of person who in prison would eavesdrop on private conversation just to have something to tell the guards. That's the type of person he is. Okay, the court, okay. Mr. Rossi, you know, this is starting to scream due process to me. I haven't seen any of these exhibits, and I don't really, frankly, I don't know anything about any of this. And I'm not distancing myself from Mr. Baldwin. I'm just saying I have no connection with any of these people, okay? And the idea that somehow the prosecutor is going to get to roll out a bunch of statements and exhibits, you know, testimony without us having a forewarning or any idea, anyway, of scrutinizing that seems a little outside the boundaries of due process to me. Yeah. If this was an investigation, charge them. Let them have time to respond. But no, it was really, really important to make this ambush. Plus, again, I get back to what is the relevance to what is going on in this case. Why are we going to use an open courtroom to air an ancillary matter? It's not really connected in any way at this point to the proceedings that are ongoing, whether it's the Franks issue or anything of that nature. And I will tell you this, I am prepared to show the court this. I would rather do it in private. This problem has been a problem from the very beginning. I have 10 pages of deposition transcript in this file from my deposition, our deposition that I took of Trooper Holman in this case. And in that deposition, he talks openly about how there were crime scene links from the very leaks, not links, crime scene leaks from the very beginning. It was. Somebody sent them to me. And those are not the things the defense had. Can I show it? No, because over here, technically, those images are regarded as nudity of minors. So I had to pull my ass down to a fucking police officer, to the cops, and say, this is a case I'm covering. I got sent this to me. It's a crime scene photo. Technically, under Swedish laws, it means this. So no, I can't show it because it is in a secure place with zero access to internet. So thank you. Don't send me stuff. Tell me where to find it and I can evaluate it myself. But just don't send me those kind of things because it got me into trouble. Let's continue. It continues. Unequivocal crime scene leaks, and as soon as this crime occurred, there were investigating information that had been released because there were lay people that were part of the search party, and the implication is, and I got the transcript, is that those people had found those girls, started to essentially disseminate or distribute information, and law enforcement essentially tried to catch up with them. But it was really too late, as you might expect. Once it gets in the hands of the public, it's too late. So he told us that. Almost volunteered that information to me in the deposition. The second concern I have is that I think I shared with the court just an example. A week or two ago, somebody sends me a court TV, bit, and I can assure you, I've never watched one of those bits on the case. I don't even know if I've ever really watched court TV. Maybe back when Simpson was ongoing, I don't know. And in that bit, Barbara McDonald is talking 2 different occasions. She mentioned how she's getting information from investigators on the ground that were at the crime scene. Now, we can all draw implication about that, but most importantly, it was corroborated by the fact that she was holding in her hand documents that I know to be directly related to the Purdue report. So yeah, that's the investigators leaking. I mean, I saw the pictures. I know where those came from. And if, the point here is, I'm going to say this maybe a little loosely, but forgive me, I don't care. I don't care that all this stuff is out there because it's been out there for 5 or 6 years. I don't have time. He doesn't have time. He doesn't have time to sit and try to marshal all of this stuff while this case is ongoing because there's no end to it. But the point is the court needs to have some context that this is nothing new. I'm super. I lost sleep over the fact that there's a man who's dead and I don't even know. Yeah. The person doing the leak allegedly self-ended after a phone call with, I believe it was Holman. He ended himself. And frankly, Andy doesn't know, and it's tragic. I don't know what life circumstances he had or what surrounded this. None of that information has been shared with us. But at the end of the day, what's going on out in the cyber world and in the public, as you might expect in a case of this magnitude that's been publicized for 6 years, was beyond our control before we even got involved. Folks, there's a lot of dead people in this case. One of the I read a few weeks ago, or a week ago, or a few weeks ago, the Odinist report. The 3 authors of that, one is dead, murdered by a former corrections officer who allegedly was an Odinist. One was arrested 3 days before trial, before he was supposed to testify for the defense. He was arrested because of bogus claims because he was in a unit with, what's it called? A unit that made home visits regarding child safety. And they claim he fraudulently wrote false reports. So 3 days before the Delphi trial, they arrest him because, and I mean, seriously, people are getting killed, people self-end, people get arrested if they are somewhat against the prosecution in this case. Now, stuff happens sometimes. Sometimes it's pure chance. Sometimes it is a quinkydonk. There's a lot of coincidences in this case. Mr. Baldwin says, there's even a guy in Florida who says the guy in Texas who leaked all this stuff has received from a disgruntled Carroll County employee a whole file filled with stuff and photos included. And I haven't even seen the photos that were leaked. I don't know what they are, I mean, if this could be a set for a formal hearing in the future where we have a chance to do it the right way, then that's one thing. Yeah. If Judge Gull wasn't a cunt, she would have gone through with the trial and then afterwards she would have had this hearing. No, because the defense attorneys pissed her off by bringing in stuff she didn't want in, like the Odinist theory, other people confessing that the investigation was conducted by people who have one brain cell combined. No, she didn't like that because she wanted Rick Allen convicted, and this wasn't a part of her plan. And the counter way to counteract anything. If I know what it is, I can, I know what this is, or I don't know what that is. And it's, and in the meantime, we can, I don't know, honestly, this is the lowest point of my career right now. Because somebody did what they did to me, and there is nothing to do with Richard Allen. The court says it certainly does not. Mr. Walling, Richard Allen needs to have counsel there, so I just don't want to go in there and not be able to fight back. With evidence that or witnesses that we have to counteract whatever they claim that they have. So the court, okay, here are my thoughts in no particular order. I don't know how many folks are out there. Bullshit. You made sure media was there. And I certainly don't wish to air publicly to the world the concerns that I have about this matter. You lying sack of whore. This was the only hearing she allowed cameras in the courtroom. She was all about airing it out. My intent in having this hearing was to go through some of the pleadings that we have not yet decided. So I was going to start with reminding everybody about the decorum order, reminding everybody why we're here, to shut up, etc. There have been reports to my sheriff about disruptive people. There was nothing disruptive. And I will remind people, if they are disruptive, they will be removed, and my sheriff is fully prepared to execute arrests if necessary. But I know we've seen in our other hearings, people have been disruptive and hateful. You whore! No! You were the spiteful person in that. You have always been the spiteful, hateful person doing illegal stuff in the courtroom, including, but not limited to, confiscating phones and tablets and then destroying them, which is illegal in the state of Indiana. The only legal remedy for disruptive in court with an electronic device, you temporarily take care of it, and then after the proceeding, you hand it over. Because I know I've seen in our other hearings people blah, blah, blah. So under the rules, under the canons of judicial conduct, you have no fucking idea what that is, you bitch. I'm required to advise people within the room that the media is here and they are filming. How about that? They're doing pool coverage, so there's only 2 cameras in the courtroom and everybody's going to get coverage from that. And then I want to talk about the pleadings. Defendant filed a verified motion for immediate transfer of custody. The state filed its response. The motion, again, has a lot of inaccuracies and some speculation. You can't have that finding before it's argued, you cunt. The motion, again, has a lot of blah, blah, blah. And then it has been refuted ably, I think, by the affidavits that have been submitted by the state. Yeah. What Mr. McLeland never lies, and the defense attorneys always lies. That is Judge Gull for you. And I'm going to deny the motion. Of course you are. Denying the motion without a hearing. That is her MO. The defendant then filed a motion for broadcasting order. The state filed its response. Your motion's overbroad. It's got a lot of irrelevant verbiage in it, and I'm required to consider individual requests for hearings, so I will. If the media wishes to have an individual request submitted, they know fully well how to do that, and I provided to cancel all of those requests that I've gotten so far for this hearing. So if you want to find them for particular hearings, you're certainly welcome to do that, but the media is all over this, and they're not. They know how to do this. Yeah, but you don't care, because you denied every single one except this one, where you encouraged media to show up. Mr. Rossi, yeah, I was just trying to understand. Are you suggesting that you're going to determine that on a case-by-case basis or a hearing-by-hearing basis? The court, hearing by hearing. Mr. Rossi, okay. The court, yeah. Mr. Rossi, all right, okay. I just wanted to make sure I understand what the court. The state filed its motion for leave of court to subpoena the third-party records. I think that was directed again to the DOC. I clearly can't grant that. No, this is one of the things where she couldn't. She had no legal right to even have the judge's discretion area around it. I'm going to grant the defendant's motion to quash, but if you continue to raise his medical and mental health in pleadings, that's fair game then for that to be provided to the state. You've also filed, Mr. McClelland, a motion for future pleadings and filings to be sealed prior to being released to the public. Of course you have. I've not gotten a response from the defense. Mr. Rossi, can I speak on that? The court, sure. Mr. Rossi, I think it's important to note that, we had this discussion come up before, and there was basically, we decided, okay, we're done sealing stuff. We're going to make it public. Before we filed that Frank's brief, I had a long conversation with the court reporter, Karen Allen, over in Delphi, because I wasn't sure about Allen or Roller. I always want to call her Karen. Mr. McClelland, Allen. Mr. Rossi, Karen Allen. Because I wasn't sure about the mechanics on how all of this stuff was moving from Delphi to your office. And I know you had set up some kind of a website or something that people could access. And I was understanding and speaking with Miss Allen, I'm not blaming her for anything, but that when we find these things, they were going from them and they were hitting a button. We were filing with Carroll County. They were hitting enter and they were sending it to you, and you were essentially filtering this stuff, or at least you were seeing it before it became public. The court, nope. Liar. Judge Gull actively did not make... sometimes we waited for months to even see if something happened on the docket. Months. Oh yeah, this is happening in chambers. This is not an actual hearing. They are in her room now. Mr. Rossi, and so that's the way I in talking with her, that's the way I understand the mechanics, which I think is what happened to a pleading the other day, from what I understand. We find something, and you either put it in a queue. I think there's anyway, I tried to do some homework on that, and that's what Mr. Baldwin, I was a part of one of those conversations, and that's what she said. The court, so does that need a hearing? I'm happy to have a hearing on that. I don't have a problem with that. Yes, you do. Yes, you do. Mr. Rossi, well, I don't really, I guess. I'm just telling you for context. That's what Mr. Baldwin, I mean, could there be a happy medium of we file it confidentially, and then so the judge then gets a chance to review it first? Because that's what we thought was going on anyway. But if that's not what's going on, the court, no, it's being filed confidentially if you mark it as such. Mr. Baldwin, I know. Yeah, I know that now. The court, I had my staff mark the memorandum confidential after it had been filed and disseminated to the public, because the actual warrant was in there, and that's covered under a miscellaneous case number. I'm happy to have a hearing. Yeah. One of the warrants that was in the Frank's motion was filed under a different case number than this one. Of course they couldn't find it, because somebody made sure it was not filed under the correct case number. Mr. Rossi, well, what is your ruling? I guess to make sure I understand. I don't want to fight about something that we don't need to argue about. The court, I haven't ruled on that. Mr. Rossi, okay. The court, you haven't filed a response on that. Mr. Rossi, yeah. The court, my question is, do we need a hearing on that, or do you wish to file a response? The Frank's motion clearly needs a ruling, and I'm working on that. Notice she didn't say a hearing, which is almost when a Frank's motion is handed over, you kind of have to have a hearing about it. And here she says the Frank's motion clearly needs a ruling. The motion and exhibits are about 1,500 pages, and there are hours and hours of interviews that has been made available that my IT staff has now cleaned to make sure they're okay. We already talked about that. And then, I mean, that brings us to my concerns that I that I raised with all of you on our phone call. And I'll write everything out, and this is what I intend to say in open court. Here we go, folks. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing of November 22nd of last year. The very first hearing when they were appointed. Mr. McLellan filed a motion for gag order, and we were in chambers, and you assured me, gentlemen, we don't want the media in our lives. We will not try this case in the media. Liar, that's not what was said. And less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. That press release was in reply of some shit McLellan put out there. But she only blames the defense. I don't know. I think you knew or should have known those were potentially violative of Rule 3.6 of the Rules of Professional Responsibility. But it is that press release that prompted me to issue the order December 2nd, granting the gag order until further hearing. April 18th of this year, you filed a notice of tort claim against the Department of Correction. You stated in that notice that it was your intent to pursue our client's claims against you. The full amount of damages sought on behalf of my client is unknown. I don't know how you could do that in representing Mr. Allen in a criminal matter and then launch off into a civil matter. It's not your problem. Judge Gould, you have zero input in any civil case. Zero. Absolute zero. I think that's inappropriate. May of this year, we were notified by the state of the Brandon Woodhouse arrest and the subsequent discovery of your work product. And I think it was an outline that you created for yourselves with the discovery. It was pretty detailed. The Brandon Woodhouse arrest, yeah. The discovery of your work product, yeah, that's the, if I'm not absolutely out of it, that was the crime scene things. It was pretty detailed. I don't know if that's the right word. That apparently happened in December of last year, and that was not revealed to anybody, not shared with the court. It wasn't shared with you, although apparently you guys knew about what was going on. Mr. Baldwin, he didn't know. The court, you knew. Mr. Baldwin, I did know. The court. So then Mr. Woodhouse gets arrested, and here we are. Grossly negligent to email that to the wrong Brad. Oh, that's the wrong email. Yeah. He put in Brad to get it to Brad Rossi, but it got into the wrong person. Folks, those things happen. It happens. Not often, but it happens. What should have happened was Woodhouse, hey, you sent this to the wrong person. Oh, yeah, I did. Please delete it. And that's the end of it. You notify the court. This happened. It's being deleted. Blah, blah, blah. End of story. But a year later, she's still making it an issue. Your pleadings on the safekeeping order contained inaccuracies and falsehoods. That was proven in the hearing we conducted in June. We just read that fucking hearing. There were no allegations of falsehoods and inaccuracies. Now, the safekeeping order, there were no inaccuracies and falsehoods. When did you make that? When? No, she keeps it bundled up, and then she springs it by surprise. The evidence presented by the state clearly demonstrated the falsity of your claims. She's a liar. She knows she's a liar. She does it because she wants to get revenge on Rosie and Baldwin for having the audacity to actually represent their client. And then the last couple of weeks that we've been dealing with, the state provided you discovery. Yeah, but not all of it. Not even half of it. That has been severely compromised. Don't care. We now have an ongoing investigation. I'm not going to call it a criminal investigation. I don't know what it is, but it's clearly being investigated by the state of Indiana. It's being investigated by the same fuckface, Mr. McLeland, who has been hiding stuff from the defense. Can you spell biased? Sorry. Everyone involved has sought counsel, including you, Mr. Baldwin. You have had an attorney enter a written appearance this morning. I don't want to get into the investigation candidly. You are the constitutional authority for the state of Indiana. If you choose to pursue it, that is up to you. If you choose to abandon it, that is clearly up to you. I am glad to hear that you have cooperated, but Mr. Baldwin's attorney has clearly shared, I don't know if you've seen this pleading. Mr. McLeland, I saw it, Judge. Yes, I got it kind of late. He emailed us, and then the court, okay. I saw that was filed on the way here. Oh, thank you. Thank you. Gifting a membership. Thank you so much. Deeply appreciated. Deeply, deeply appreciated. It was gifted to Lady Star. And now you, Lady Star, have access to all my members-only content. You have access to... most of my videos goes out to members first, for everything from a few hours to a few days, and I need to put out a new fresh link to my Discord. So all of that for just $3 a month, or if you get gifted one. Thank you, thank you, thank you. All right, let's continue. The court, well, yeah, so he has clearly shared it in his pleading, down to the fact that an individual has committed self-ending, including the fact that you left material all over a conference room table, accessible to anyone. You can't. No. It's not accessible. You have to actively go through, uninvited, through a front door, turn into a hallway, and then into that conference room. That is called burglary. And this is a friend of yours who apparently you have consulted with on this case. Very early on, not at this time. So again, it is up to you if you wish to pursue that. I'm looking at the totality of the circumstances. Oh, I hate this fucking expression. Totality of the circumstances. I really, really hate it. You know, when I look at a suppression, the case law requires me to look at the totality of the circumstances, and that's what I'm doing. And it pains me to say this. No, it doesn't. But the totality of these circumstances demonstrate gross negligence and incompetence on part of the defense team. You can't make that finding, you can't, without a hearing. You are not allowed by law to make that conclusion without a hearing. By law. And we will get into that with the Supreme Court hearing. I am unsatisfied with your representation of Mr. Allen because Judge Gall just wanted them to roll over. I'm gravely concerned about his rights to have competent, non-negligent representation. That's Jesus fucking Christ. He currently doesn't have that right now because what you have demonstrated its negligence and incompetence. Now, I'm sharing my thoughts with you privately. No, you are not. Judge fucking Gall. I don't want to say this in open court. Yes, you do, because you invited for the first and only time media to this hearing. I will encourage you to talk privately about what you wish to do. I don't want this coming out. Of course you don't, because you're doing illegal stuff. Yeah, of course you want it hushed down. It is not where we need to be with this case, but I will. But you don't know that. You've just now been made aware of my concerns and where I'm landing. She admits it. She just told them this is what her ruling is going to be on a hearing she never planned on having. So if you wish to have a private conversation, I will encourage you to do that. I don't believe your client is here yet. No, he's not. Clearly, you know to speak with him as well. So, Mr. Baldwin, I'm not good at reading between the lines. The court, you're a lawyer. That's what you do for a living. Mr. Baldwin, when you say have a private conversation, are you talking the four of us or the court? I'm talking about you. I'm not accusing the state of gross incompetence and negligence. Of course not, because you have your ass buried on McLeland's face. He will do anything you say, and you give directions on what he should say or do at any, more or less any point in time. So of course you don't find McLeland incompetent because you tell him what to do. I'm finding gross incompetence and negligence with you. She can't do that without a hearing. So, okay, so Mr. Rossi, forgive me, go ahead. Mr. Baldwin, no. Mr. Rossi, I mean, obviously, reading the tea leaves here, what you're giving us a chance is to do is bow out gracefully, if you will, if that's the right term. Is there a scenario where the court would accept if I stayed in the case? I mean, I'm a team player, and I'm not the kind of guy that just bail out on somebody just for the sake of doing it. But I think it's obvious that, you know, he can speak differently, but I'm not as connected as some of, you know, this most recent circumstances as he is. Yeah, it wasn't his office. Hi, Sloothy. Sloothy Goosey. Yay. Mr. Allen is in a situation where he's going to have counsel that if he has new counsel, it's going to take them a year to get up to speed with the depth of information that continues to come in. And so I think that his Sixth Amendment right matter. And, you know, I'm probably the one that can at least move this thing forward with some sense of a judicial economy. I don't like it, and that's not what I intended to do when I came in here today, but that would be kind of a worst scenario on our side, you know, I guess. And so is it an option that the court would entertain? The court, no. This is an ambush. Yeah, we know. The media was waiting in the courtroom the only time she allowed cameras in the courtroom. All of this was pre-planned with McLeland. I would love to get my hands on the communications between McLeland and Judge Gull. But that will never happen, sadly. Mr. Rossi, so basically what you're saying is you guys either quit on your own accord, or you make me fire you. That's what the court. No, I'm saying to you that this is what I plan to say in court on the record when we convene at 2:00. Well, so is the culmination of that you're going to remove us from the case? The court, I will, based on what I've just shared with you. Without a fucking hearing. The court, and I'm just giving you the opportunity to have a conversation which, how do you want that to go? I don't want to do this. Fuck you. Yes, you do. I don't want to do this, but if I will, I will if I have to. This was pre-planned. Probably weeks in advance. Mr. Baldwin, should we bow out gracefully? As Brad says, how would we even have a hearing? How would that go? Because if we're out of the case, then Mr. Rossi, then you're going to go ahead and rule on a bunch of stuff without lawyers in the room. That's the court. No, I wouldn't do that. If you decide that your best course of action is to file a motion to withdraw, you can do that today. And I'll send Mr. Allen back to the DOC after you had a chance to speak with him. Mr. Baldwin, would that happen before the hearing or after the hearing? Your motion to withdraw would happen before the hearing. Mr. Baldwin, okay, that's what I wanted. Yeah. The court, yeah, because he has rights which you don't give him, George Gull. And I don't want those rights compromised by having a hearing with him not having counsel. That's not the hearing they are talking about. The hearing is regarding incompetence and gross negligence, which you are required to do by law. It's not a maybe. It's not a, oh, if you want to. If you're going to disqualify somebody, there has to be an evidentiary hearing and then a finding of fact and then a ruling. There's no option of that unless you're Judge Gull. Sleudy says, good thing she came on and lied on TV saying we had an unexpected turn of events, because that's how we've been able to have AI clone her. Be careful with AI cloning other people's voices. Be very careful with that. Not legal advice, but before you continue with that, you might want to consult a lawyer. I'm just saying. At least over here in Europe, you have to have explicit, if you're using the likeness or the actual voice or the likeness of a voice that is easily recognizable. Oh, you spoke to Indiana attorneys. Okay, good. I'm just watching. I'm just watching out for you. If he chooses to withdraw, that his financial situation hasn't changed and he would still be entitled to court-appointed counsel. I can't imagine that he has the ability at this point to hire counsel. I don't know that. Mr. Baldwin, Brad and I need to talk. The court, yes, you do. Thank you, gentlemen. Mr. McClellan, yep, thank you. Off record. Thank you, Jody. You're welcome. Okay, Jess. Mr. Rossi, all right. So obviously we're trying to figure out how to address this issue with very short notice, very little notice. The first thing we did is really to talk to the client. The court, Mr. Rossi, our client is a big part of this, the biggest part of this. And he has communicated to us that he does not want us to withdraw from his case. He wants us to continue with his representation. He understands, I think, that he's not the gatekeeper, or he doesn't have the authority to really force the court to do that. He would like to say that on the record. We asked him if that's what he wanted to do. We suggested maybe he would do it in chambers. It seems a little bit of a difficult position to put a man who's accused but not been found guilty, put him in a courtroom and have him, have to speak in these circumstances with 15 minutes notice. Andy and I'm going to speak for myself. I'll let him speak for himself. I'm going to file a motion to withdraw. This is what they claimed. They did it voluntarily. There's nothing voluntarily done here. They know that there's no actual evidence. There's been no hearing. They haven't been allowed to defend themselves. They were put in a position to remove themselves or being in a kangaroo court where Judge Gull would have reamed them out for an hour straight. And I don't want to do it, but I don't think that I have a choice in this point. The options I've been given without any notice by the court really are either I withdraw, I'm going to be publicly shamed, and that's the way I see this. Now, Baldwin and Rossi here it's good that they explain this on the record. And I think that public shaming is there's not only a professional element to that, I think there's a personal aspect to that too. But when the media is teed up like this, and we show up here today with the court having told us that we're going to conduct some business, then that somehow bleeds over into a forced resignation or whatever you want to, however you characterize this, that, I don't feel like I have any other choice professionally. I have a life beyond this courtroom and beyond this case, and I have a family too, and I have a law practice. But I think we've been given some notice of what we were actually. If this would have been framed in a pleading format or some formal disciplinary claim, which there's a process for that in our business, then we could have come in here today with an opportunity to refute some of those things that you clearly had, thought through and prepared before we got here. And we didn't have that opportunity. And it's the idea that I'm going to have to go in here in an open courtroom and essentially defend myself against claims that I don't agree with without any notice and without any opportunity, I think is unfair. But I also have some common sense. And, me going in there and standing my ground because my client wants me to is just going to make things worse for him. And so I'm going to withdraw my appearance. I'm going to walk out of here. I'm going to go down to my car. I'm going to call my staff and have them prepare a motion. I'm going to withdraw my appearance. But I'm doing it because I don't think I have any other choice professionally. Not because I want to, not because my client wants me to. And I respect the court has an opinion, but we are professionals and we can disagree. The court, of course. And, I am extremely, I'd say frustrated, probably a soft word, with the idea that we showed up today without any real opportunity to prepare for any of this. And I just think it's improper, and that's where I am, and that's my position. The court, well, I think we talked about when he asked for a disqualification. He didn't ask for a disqualification. He asked if this was about a disqualification. And I indicated on our phone conversation, I'm inclined to do that. Mr. Rossi, it was a phone conversation that was not on the record, and then some follow-up emails. The court, true. Mr. Rossi, there's an informality to that. The court, true. Mr. Rossi, very clever here. He's explaining himself, and he's making her admit that most of this was prepared by her off the record. And you also said that you hadn't even done any research, and you hadn't, had time to talk to a senior judge and all these other things, and he hasn't filed a pleading with the court either. The court, no, I'm doing this on my motion. You can't do that. Mr. Rossi, and I'm a lawyer who practices in a lot of courtrooms, and I've been through some disqualification actions. In 20 years, I've never had a disciplinary complaint in my life that's been confirmed, if you will. But I've seen lawyers disqualified. And there's a process for that. And it's not this. With all due respect, where you walk into somebody's office, a judge's office, and they read a prepared statement to you, essentially. That statement is an indictment on my professional, activities. And then you're handed essentially a sheet of paper with two options. And one of them is, I'm going to go out here and shame you, or you can quit. You can understand how upset that would make any lawyer. And I don't think it's the right way to handle this from a due process standpoint. So I have no choice but to, withdraw my appearance. Because I'm not going to go in there and take a public shaming without having any notice of it. That's where I am with it. Mr. Baldwin, I'm the same withdrawing. I mirror what he said. I do appreciate giving us the advance notice. If there is some appreciation for that, I do appreciate that. But beyond that, I wanted to take this, and finish it out. I'm stunned. I don't know what to say. So I'll just say I'm moving to withdraw orally. This is the difference between Baldwin and Rossi. Rossi told the court he will go back to the office and prepare something. Mr. Baldwin withdrawing orally, acknowledging his withdrawal. The court, okay. Mr. Rossi, is the court going to generate some further instructions on what to do with all of this discovery that we have? And the court, I already have. Everything pre-planned, everything was already done before they set foot in that room. McLeland and Gall together made this happen because the defense attorneys actively defended Rick Allen. Mr. Rossi, and this information, and the court, there's an order. I granted the state's protective order on discovery. Mr. Rossi, no, I'm talking about my possession of all of this information. Am I to take it out to the trash can? Am I supposed to wait for another attorney? Is the court going to give us some guidance on how to move all of this information from one law office, the court, I did, to another? The court, when I granted the state's protective order, I think it's the last paragraph of that protective order, directs you to return it all to the state of Indiana. Ambush. Everything was already done. All the copies already, whatever you gave them, they are required under that order to return to you. Mr. Rossi, at the conclusion of the case, or our representation, or your representation. Mr. Rossi, I know what order you're talking about. I read the order before I came today. The court, okay. Mr. Rossi, so we're supposed to just take everything back and give it to the state and then just retain our work product until somebody asks us for it. The court, your work product is your work product. I mean, I would hope that you would share that with successor counsel. I would hope that you would help successor counsel just with the transfer of all the information, because that is in your client's best interest to do that. That's entirely up to you. That is your work product that you have developed. I mean, clearly, the discovery is required to go back to the state. Mr. Rossi, okay, thank you. What do you want to do with Mr. Allen? The court, I can transport him back to the DOC. Mr. Rossi, do you want to make a record with this? I mean, I think it's appropriate that the court let him speak into the record his thoughts, unless the court just accept that as notice that those are his opinions. The court, well, you wouldn't lie to me about that. Mr. Rossi, I would not lie to you about anything. The court, so of course, that's your representation, that's what he would say if he was brought in here. I can't imagine the DOC being comfortable bringing him into my office. I would not be comfortable having him in my office. Cunt. Mr. Rossi, would the courts also be inclined to mark as an exhibit the prepared statement, so that is part of the record? The court, I have the record rolling. Mr. Rossi, okay. The court, yes. Ms. Bowen, so we're going to leave, I guess, and you're going to, how is this? You're just going to go up on the bench and say, the court, I will just indicate too, Mr. McClellan is going to be in there with Mr. Luttrell, and I'll just say that we have had a turn of events. The defense counsel is withdrawing, and that's all I'm going to say. Mr. Baldwin, can you wait for us to get out of here? The court, of course, and we can have you, I don't know where you're parked at. We have a hearing set for October 31st that I'd like to keep as a trial setting, an appointment of new counsel, and if you can get things together by that date to return to Mr. McClellan, that would be good. Otherwise, if, with your permission, I would give successor counsel your contact information. Mr. Baldwin, okay. Mr. Rossi, okay. The court, where are you parked? Mr. Rossi, nice to meet you. Sorry too. Inaudible. Luttrell, inaudible. 19 inaudibles. Just right out there in the front of the building. I mean, there's a parking lot. There's a little parking lot right in front of the building. I don't know what. Everybody's in the courtroom, so I don't think there's anybody out in the hallways. Mr. Rossi, I'm going to go get my staff member. I'm going to have her. I don't need any. We'll rendezvous at some point and try to get the stuff back. Mr. McClellan, okay, that's fine. Between Steve and I and Sarah and you. Mr. Rossi, okay. Mr. McClellan, we will get it all. Mr. Rossi, that's fine. Mr. McClellan, done. That's either Sarah. Mr. Rossi, thank you. The court, thank you. This concludes the proceedings had in camera on October 19th, 2023 in this cause. Record of status hearing held on October 19th, 2023. Appearances for State of Indiana, Cuntface meet Cuntface and James Luttrell. No defense attorneys. Proceedings. The court. All right, we're on the record in the State of Indiana versus Richard Allen. Thank you for your patience, ladies and gentlemen. Thank you, Mr. McClellan, Mr. Luttrell, for your patience. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. Mr. Baldwin made an oral motion to withdraw. I granted that oral motion to withdraw. No, you didn't. We just read it. There was no acceptance of it. Forgot that. And Mr. Rossi will be submitting a written motion to withdraw. I'm assuming within the next couple of days. They have confirmed with the court that Mr. Allen's financial situation remains static, meaning he is continuing to be entitled to appointed counsel. I will reach out to public defenders to make that appointment. As Mr. Allen is now without counsel, I've ordered him transported back to the DOC. Mr. McLeland, I know that we've already scheduled a hearing in Carroll Circuit Court October 31st at 9 a.m. I'd like to maintain that hearing if we can, please. Attorney, plug here. Yes, Your Honor. The court, I think at this point we can have counsel appointed. I'd like to set a new trial date, obviously. I don't believe counsel will be prepared within the next couple of months to try a case of this magnitude in January. So we set dates for that trial. I think we need to set a date as well for the suppression hearing that was filed now by former counsel. No, you can't. That is moot because you said so. I've asked the attorneys to provide all of the discovery previously provided to back to the state of Indiana. I know I entered a protective order on the discovery, and honestly, I don't remember when that was. I think it was in April of this year, perhaps, maybe sooner. But the attorneys have been ordered to provide all of that discovery back to the state. And if you would maintain that until such time as it can be turned over to successor counsel, I would appreciate that, Mr. McLeland. Mr. McLeland, yes, Your Honor. The court, I've also asked the defense attorneys to cooperate with successor counsel. They're not required to do that, but I think that they will in the best interest of Mr. Allen. They're not required to provide any of their work product, but they will be required and have indicated that they will cooperate with successor counsel. So obviously, without counsel, Mr. Allen's hearing cannot proceed. I apologize that I know many of you have been waiting for several hours. I know, Mr. McLeland, you and your staff, and you had some witnesses here that came earlier to have their hearing, but clearly this is outside of our control. Everything was in your control, you piece of human garbage. So is there anything, Mr. McLeland, that you'd like to state for the record? Mr. McLeland, no, Your Honor. I think we could address the other issues at October 31st. The court? Okay, all right. With that being said, we are in recess. Thank you. I'll see you in October. Mr. McLeland, thank you, Judge. This concludes the status hearing had on October 19th, 2023. This is the 31st. But that is for another time, because now, folks, this is the Indiana Supreme Court hearing. Here's argument in the Delphi case, January 18th. Now, meanwhile, because between this date, October 19th, and up until Mr. Baldwin and Mr. Rossi was reinstated, Judge Gull appointed 2 new attorneys to Rick Allen's case. Both attorneys were appointed by her personally. One of them was a Facebook friend. Now, that's maybe not that unusual, but in these circumstances, it is interesting. One of the attorneys had disciplinary issues before. One of the attorneys had been on a daytime show expressing his belief in guilt regarding Mr. Allen. And she still appointed them. Here's what she didn't expect. After Rossi and Baldwin were reinstated, one of those attorneys went public in an interview saying they stood behind the Franks motion. So, folks, you can explain away Baldwin and Rossi Oh, they were just throwing things at the wall and hoping. But then they were disqualified. Judge Gull appointed 2 attorneys personally. This next set of attorneys still said, we are fully behind the Franks motion. 2 sets of attorneys were behind the Franks motion. All right. The hearing. Let's see. Should I be up here? Yes, of course I should be up here. Have you hit the thumbs up yet? If you haven't, please do so, because you know you should. It's really not that hard. Let's see here. Yeah, more of you should. A lot more of you should. There are 47 out of 64, but I have a grand total of 200 unique views so far, and 47? Not good enough, folks. Not good enough. All right, let's listen to this.
Good morning and welcome. We're here this morning to argue in the case of State XRL Richard Allen Relator versus Carroll Circuit Court and the Honorable Fran M. Gull respondents. Counsel for Richard Allen, the Relator, will argue first. We're hearing this case, writ for mandamus and a prohibition case. Representing the Relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnicke. Good morning, Ms. Winnicke, and Bernice Corley. Good morning and welcome.
Is sound okay? Let me know.
Representing the state of Indiana, at council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gull, and you will be arguing first. In the council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and counsel. Counsel, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes. So you ready to proceed?
I am.
All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that the court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review, this behind the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes, and his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under the circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of the court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see that.
Yes, I know it's reverb here. I can't do anything about it, sadly.
This as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these
Okay,
circumstances.
so, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons. If they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion that the trial court judge has.
There's an absolute duty to follow the client's wishes. And when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary
And
decision.
the absolute duty is found under the Sixth Amendment.
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this, constitutes three situations where in their totality, they clearly place the limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record that had preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that.
You have a lot of concerns, but I've had a couple. You got a lot of concerns, and you do a nice job laying those on your brief. But there's a couple of things. You're asking the court to issue a ruling for speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor.
I will see if I can find. Ah. Here's a better.
Meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impied the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes. And his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here.
We already heard this.
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these
Okay,
circumstances.
so but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary
And
decision.
the
in that
absolute
regard.
duty is found under the Sixth Amendment.
Judge, I think the
I'll
absolute
just
duty
pop
could
off and
be
grab
under this
myself a
court's
beer
case law,
because
but I
it's
think
10
that in
p.m.
the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality, they clearly place the limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record that had preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they
from
sat
being
on it for they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor, they had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered.
Yeah, they had it pre-planned. that at a certain point, when they had enough, especially after the Franks motion, boom, speedy trial. Because they could. Sadly, the disqualification. So even if the disqualification was reversed, they still didn't file it as his current defense attorney. So essentially, Mr. Allen was denied the speedy trial by proxy by Judge Gall.
By the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with a senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judges. I'm aware of that. I know what's happening. I'm ready to ride or die with these lawyers. I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it. I think on the Western, if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, and you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She thought his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
yes, Judge.
That's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so what we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Bolden and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action. The judge, I'm going to go out there and I'm going to say these things. And Mr. Rosie presses at her, well, what's that proceeding going to be? And the culmination of it that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe,
Because you're saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct, Your Honor. I do think I don't think
Got a
those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the 6th
my
Amendment
concern is getting
requires.
this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge that there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error, and it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
A lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just something like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're
not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think that our rules is that an actual conflict of interest is unwaivable when you sue one party versus the other. And shockingly, that seemed to have happened in one of the cases in Indiana. So I think, but other conflicts are waivable conflicts, other than that one rare exception.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that yet, just, no. because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to a press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
Well, counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance of counsel.
But even if it did,
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case, it would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent the conflict of interest, injecting herself into that. And I do think that you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples, these are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask you, with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Yeah, I mean, that is a really good question from Justice Goff. There was actually nothing that stopped Judge Gull from making an accurate hearing once they were reinstated and finding the same things. And she didn't. Because even that corrupt cunt realized with the Supreme Court's decision to reinstate the attorneys, she had to make factual findings that had no support in law. And it would be right up to the Indiana Supreme Court again. And then their remedies might have been more severe.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to?
No, I think if there's a concern, say for example, the pretrial publicity, the press release, if you say, listen, I think because the violation says it has to affect the fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel,
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial has been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, to the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers. But it's hard to look at this record and not get the impression that, perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
counsel.
struggling with that. I'm butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice. That's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. He's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat, as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion, when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I look at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for a matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even ask for this relief from the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence, and frankly then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So
Well,
you're
also, you think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so I'm
violation.
clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in 2 ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done. There's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So
There
did she exceed her
there
authority
wasn't
by
a
the
hearing
manner
in
that she
chambers.
presented them back in chambers saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of
So
procedure.
there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, she was.
Well, not really, because nobody in the history or recent history, the last 100 years, has ever done or thought of doing what Judge Gull is actively doing. And I can bet hard-earned money on she's doing it in more of her cases. This is just what Judge Gull does. And she's allowed to do it because the judiciary refuses to put a foot in her ass and kick her to the moon. No, for some odd fucking reason, when judges are talking about protecting the integrity of the judiciary, they almost never talk about, we need to kick that motherfucker out if we want to have some kind of credibility. It's almost always about protecting someone, a slap on the wrist or something, but never, hardly ever acknowledging that some people should not be judges, should not be lawyers, should not be prosecutors. Just some people deserve, 95% of all homeless people do not deserve to be homeless. Judge Gull deserves to be homeless. Homeless, unloved, gone away, and when her time comes, when her Lord Satan brings her back, there will be no tombstone. But no, she's still a judge. She is still a judge.
The trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know because she said then at the hearing on the 31st, what's changed? So, which means.
Well, we won't know
do
what
know
would have
that.
happened at a hearing that never happened, but you're right. I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel capable of making?
I keep getting back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney to get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently weighed the conflict in that case. And there was only a potential conflict. Wheat
It was
weighed
a
that
major
conflict.
conspiracy with lots of different people playing. I mean, in the Wheat case.
Wheat
I don't see
himself,
Wheat as tucked as neatly as you.
Yeah, and in the Delphi case, you have Judge Gull conspiring with McLeland and some of the investigators, in my opinion. We have the investigators conspiring with McLeland about hiding evidence from the defense. We have the investigators conspiring, in my opinion, with prior suspects. Suspects who had confessed. I'm sad that Rick Allen is in prison. I hope his appeal will create case law, new case law, because, yeah, the Wheat case is extraordinary. The Rick Allen case is worse and should be, I hope to everything holy that this is done hopefully within 5 years. Oh dear, sounds like another Canton. Oh, Nicola Cox. Oh, believe me when I say this. We wish we had Judge Bev in this case. It's so much worse. At least in the Karen Reed case, you could watch it. Judge Gull denied every motion of everything. No cameras, none whatsoever. She even in court told a witness to not lean into the microphone, making it a lot of the things that happen in court, even with audience there, it was so quiet. And thank you so much, Iwi, for your super sticker. It's a pair and mic drop. Thank you so much. Deeply appreciated. I deeply appreciate every financial support. But as of this case, thumbs up, subscribe, watch it, watch my other videos on it, watch other people's videos on this. Make it hit the algorithm again and again. Yeah, the white noise machines that were suspiciously on not only during sidebars, but had an apparently uncanny ability to not stop when the sidebar stopped. Allegedly. The transcripts aren't great either. No! I'm reading from the transcripts that, according to the clerk of court, this is the transcripts that this is the same transcript as the appellate attorneys got. And it's not. It isn't. I know it isn't because it is missing the first safekeeping hearing with Judge Diener. It's not in there. No, I know the appellate attorneys got those parts as well. But we, who are entitled to the same information as they are, we don't have it.
So
Wheat
go
him-
outside, Wheat, and give me something else.
Well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But
on...
where can you point to me saying with regard to saying somebody is incompetent or negligent? We have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, Wheat went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly differential
But it
standard.
still demands an actual hearing.
For us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold conditions precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel or we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me
Would
offer
that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it. And
Oh,
and then
fuck
see
you.
if he had a knowing and intelligent interest in having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you, Mr.
Your Honors.
Gutwein. Ms. Sanchez.
All right.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen, counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will
Do you agree that with under U.S. Supreme Court Precedent Gonzalez, if there's a mistake made in the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances.
Yeah, them, because it's all they have. The Wheat case. And I'm hoping that, because now when Rick Allen is convicted, it will be appealed. My hope is that either the appeals court or the Indiana Supreme Court will go scorched earth on McLeland and Judge Gull, making new case law, making Wheat obsolete. That is my hope here. And thank you, Miss Rattle, for becoming a YouTube member. Thank you so much. That is so nice of you. You now have access to all my members-only content. You will have access to member first videos. Most videos I publish are published to you guys first, to the members. And I have to get the link to my Discord up. And you also have your own emojis here on YouTube. Thank you so much, Miss Rattle, for becoming a member. Thank you.
On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs.
Yeah, but Judge Gull, I mean, there were never a competency hearing. So just bringing that up, fuck you.
to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant
rule, something like
weighted.
it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to the all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases.
There are
involving
none.
Multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But there's no other case out there where a judge sua sponte on her own motion disqualified based on her believing in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in,
But for these reasons, it could be conflict, it could be
the wording the judge chose is unique in itself. Another point that would help with a larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm clear, you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say, no relief today. Is that right?
No, we don't think it's a writ. There's no order. There's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
So tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? Is that, we don't know? All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Gall, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
They lied to the Indiana Supreme Court about We don't know what Mr. Allen wants. It's unclear, yada, yada, yada. They fucking lied to the Indiana Supreme Court about Rick Allen's wishes.
We have that letter.
Yes, it's
We have
on
it.
page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what our ethical rules require them to do, which is to do a zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The attorney general and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is. But I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that's supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what Week is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana, for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Masson, Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. You pull the gentleman in, and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward. Yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client, trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being related to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise, the ineffective assistance of counsel and justices, I'm not conceding that. But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We'll be discussing the case and getting a decision as quickly as possible.
Yeah, and shortly thereafter, I mean, it was really, really fast going. They found that Rick Allen's attorneys, Baldwin and Rossi, were reinstated. They found that there was no need for pro bono. They were to get paid. Now, that didn't stop Judge Gull from not paying them for, I believe it was from between August of 2023 up until trial in October 2024. They were never reimbursed for their costs for over a year. Another one of Judge Gull, how she conducts herself, because she took it personally. What? You're actually defending Mr. Allen? You're actually putting up a defense? We can't have that. Because she was so much in bed with McLeland, Holman, Liggett, and the rest of them. She must have used every hole in order to fuck Rick Allen over. If you put her undercarriage against the wind, it would sound like a wind chime or an echo. When I tell you, and if you go back and watch the videos and the other streams, you will understand when I say, we wish we had Judge Bev in the Delphi case. It's a whole other level of evilness. It's not even close, folks. It's not even close. All right, that concludes this stream. Now, this doesn't mean we won't have more fun, because now a new stream will start. It is Slightly Buzzed Friday Law Show, which you will be redirected to. I'm going to go into the Laura Owens case, the Tonsil Twins case, the Fetal Attraction case. Laura Owens meets guys, does the hey with her legs and hey with her mouth, and after a few days they recognize, oh, she is cray-cray, and they want to get out of it. Then she claims she's pregnant. She's been claiming to be pregnant with twins 3 times. She takes out restraining orders. But now she is charged with 7 felonies, included but not limited to perjury and tampering with evidence. So we will go through some of the things with a brewski of your choice and the wheel of regrets. So I'm going to send you over to that stream now. But I'm going to send you off. First of all, thank you for the gifted memberships. Thank you for becoming member. Thank you for the super sticker. And I will see you over at that stream. But I will be sending you off with the free Rick Allen song. I will see you in a couple of minutes in the next stream. Bye-bye.
Down in the shadows where the courthouse stands, a gavel cracks a fading hands. Judge Gould, they whisper with a crooked grin, played the game where justice don't win. the people burns hot and cold. Prosecutor Mickelin, with his papers tight, wrote the tale that never saw light. Twisted words in a room of stone, left Rick Allen to stand alone. Who will answer? Who will pay? The sun don't rise on a judgment day. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Officer Holman, eyes like frost, drunk on power, the line got lost. Lock the doors, keep him inside, for justice limps where his footsteps stride.